Good afternoon, everyone. Welcome to the Assembly GO hearing on the legality of Internet poker. How prepared is California to regulate it? First, I want to welcome the committee members, certainly the witnesses. I know many of you have traveled a great distance to be here today with us, and we appreciate that effort, and certainly the public. This is the second in a series of informational hearings on the topic of gambling regulation, more specifically the legality and regulation of a potential iPoker regulatory scheme here in California. Since 2008, there have been countless meetings held among the various stakeholders and interested parties, both supporting and opposing the concept of Internet gaming or interstate iPoker in California. The legislature has held numerous hearings and taken hours of testimony over the past 7 years on the issues and challenges surrounding the potential authorization of this new iGaming frontier. Last year, this same committee held a lengthy and detailed informational hearing on the issue. These hearings and meetings have helped to identify potential problems and solutions and, frankly, have narrowed the differences among various stakeholders. I want to thank everybody in the tribal community, the card room industry, and the horse racing industry for your long-standing contributions to California's economy. And also I want to thank you for helping to employ thousands of Californians and help generate billions in revenue needed to help the state provide critical services to those in need. Gambling today in California is not the gambling of old. People can play Las Vegas-style games on gaming devices at tribal casinos up and down the state. People can legally wager on live horse races over the Internet and purchase a Powerball lottery ticket that includes players from multi-state locations for huge payouts. As technology has evolved, so has the manner in which the games are played and marketed to the customer. It is equally important that our laws evolve to ensure regulation with the highest degree of oversight and integrity. Internet poker and Internet gaming has also been going on in California for years. True, it is being done illegally, but it is happening every day in homes and on smartphones throughout California. Illegal online gaming robs the state of important revenue and harms brick-and-mortar gaming establishments that play by the rules, pay their taxes, and provide for their workers and their families. If Internet poker was legalized and taxed properly, it might not only be in the best interest of California, but also provide the state's gaming industry with an innovative option to complement their existing business model. And with an adult population in the tens of millions, California can be a leader in this new gaming frontier. As you know, in 2015, 4 bills have been introduced in the California legislature pertaining to Internet poker. While these bills demonstrate a great deal of work and progress among interested parties, there is much more to be done before a bill is ready to be sent downstairs requesting a governor's signature. I make no prejudgments about the final outcome of any of the pending bills, but I will say that each year that California legislature and the various gaming interests fail to agree on an iPoker bill, not only does it put consumers at risk while gambling on illegal offshore websites that provide few protections and regulations, but the state of California is also losing out on collecting revenue that might be used for essential programs like public safety, health care, social service, and education. As chair of this committee, I am committed to putting in the hours and the time necessary to further the discussions to create an iPoker legislative framework in California, which will lead to the creation of good-paying jobs, will induce a competitive marketplace, will provide superior consumer protections, will restrict access by minors and compulsive players, and contain strict regulatory oversight. Thank you all for being here. I look forward to today's discussion. At this time, would any of the other members like to say anything before we get started? Okay, we'll go ahead and proceed. Let's ask the first panel to come up. Ms. Lee, Mr. Hart. And Mr. Crawford. Thank you all for being here, and we'll start with Ms. Lee.
Absolutely. Thank you, Mr. Chair, members. Anita Lee with the Legislative Analyst's Office. Committee staff asked us to prepare a handout, which I believe the sergeants have provided to you, to provide a high-level overview of the various issues that the legislature may want to consider as it continues its conversations related to online poker. We hope that this information will be helpful to guide your subsequent conversations. If you turn to page 1 of your handout, we first provide a little bit of background on the federal law. So under the Federal Unlawful Internet Gambling Enforcement Act, or UIGEA, enacted in 2006, it is generally unlawful to place or receive gambling bets through the internet. However, UIGEA did allow states to authorize online interstate gambling under certain conditions. So, for example, that there were sufficient regulations that were adopted to prevent minors and non-state residents from participating. In recent years, there have been various bills introduced in Congress to legalize online gambling across the states, which would likely impact the revenues that the states could generate. Currently, Nevada, Delaware, New Jersey have all authorized interstate online gambling. If you turn to page 2 of your handout, we'll turn our attention to the various issues for your consideration. In total, we've identified kind of 4 major categories of things that the legislature may want to consider. The first issue before you is who could offer online poker. And so the legislature would need to determine who in the state would be authorized to offer online poker. The legislature could choose to permit certain existing gambling entities, such as the tribal casinos, the card rooms, or the tracks, and permit them to offer online poker. We would note, however, that currently the only industry that accepts bets via the internet is the horse racing industry. Alternatively, the legislature could allow new entities, such as private businesses, to offer online poker. Next, the legislature would also want to consider specifying licensing requirements, such as minimum qualifications, to ensure that only those entities with a certain level of expertise or reputation are allowed to operate in California. For example, entities currently interested in participating in online poker have expressed concern about whether website operators that previously violated UIGEA would be allowed to participate in California's legal market. Finally, the legislature would also need to consider the number of websites that would be permitted to be operational in California. Although the existence of multiple legal websites could promote competition, having too many websites could result in having each site not having sufficient players to facilitate games. Turning to page 3 of your handout, issue 2 is related to how would online poker be regulated. Depending on who is authorized to offer online poker, the legislature would need to designate an entity to regulate poker in the state. Options include establishing a new statewide entity to conduct this regulation or utilizing existing regulatory bodies, such as the California Gambling Control Commission or DOJ's Bureau of Gambling Control. Additionally, the legislature would also need to determine the level of oversight that it desired. This could include adopting specific statutory requirements, such as related to certain player protections, or could just adopt a general framework that would provide guidance to the regulatory entity as it promulgated regulations. This regulation would generate both one-time and ongoing costs. The magnitude of these costs would depend in large part on the level of regulation the legislature was interested in, as well as in how the regulations were actually implemented. The legislature would need to determine, however, how these regulatory costs would be funded, such as from licensing fees or from taking a share of the gross revenue that was generated. Turning to page 4 of your handout, issue number 3 is, would online poker be taxed? So providers and players of online poker would already be subject to existing corporate and income tax requirements. However, the legislature could choose to establish additional taxes on online poker. So, for example, currently, the other states that authorize online gaming currently do so by requiring that a share of the overall net or gross revenue from the poker or online gaming goes to the state. There are really 2 sources of state revenues that can manifest in this manner. The first comes from redirecting wagering from illegal websites. So several studies estimate that illegal websites receive roughly 300 to 400 million in gross revenue from Californians playing online poker on illegal websites. It's not known how many of these individuals would shift to a legal poker website if one was offered. That shift, however, would generate new revenue for the state. And the second source is related to generating more wagering. So revenue that is generated from existing players betting more than they otherwise would have, or from individuals that currently don't bet and don't participate, would be offset to an unknown extent by a reduction in existing state revenues. And this is generally because individuals would be spending less on other goods and services, as more of their income would now be spent on online gaming. Pages 5 and 6 of your handout is kind of the fourth and final issue for your consideration, which is what factors would impact state revenues from online poker. The first three factors that are laid out on page 5 of your handout, the legislature has a little bit more of direct control over. So the first factor relates to the state share of gross revenues. To the extent that the state required a share of the gross revenues from the legal website operators, the specific portion or the specific amount the legislature required would clearly generate revenue to the state. One goal would be to maximize the amount of revenue that could come in. On the other hand, if the state were to require too large of a share, operators might not retain sufficient revenues to compete successfully against illegal websites. The second factor relates to tax purposes. Currently, players using illegal websites have little incentive to report gambling winnings for tax purposes. The state could require that legal websites report such information to the state to make it easier for the state to collect income taxes on net winnings. However, this could deter some players from participating on the legal websites. And the third factor is related to legal issues surrounding tribal state compacts. Currently, certain tribes are required in their compacts to make payments to various state accounts, such as the State General Fund. The compacts also contain provisions that limits the state's ability to authorize games that would compete with tribal casinos. There have been some legal concerns that have been raised regarding whether the poker websites would violate these types of provisions. If these concerns were upheld in court, it would mean a potential loss in revenue. The legislature will want to work with legislative counsel, essentially, to assess these risks as it moves forward. Page 6 of your handout are the final two factors, factors 4 and 5. And these are issues that the legislature has a little bit less control over because it relates to how players or operators react. So the fourth factor relates to the level of player participation, which is important because that would dictate how much revenue would be coming in. So first, legal poker websites would have to compete with existing illegal ones that have little to no limits on the types of games it offers. Additionally, if the cost of playing on legal poker websites was greater than the cost of playing on illegal ones due to taxes, fees, etc., there could be a fiscal disincentive for individuals to play and wager the same amounts on legal websites. Finally, unlike illegal poker websites, the legal websites would be able to provide players with a greater sense of security and comfort. However, it's not clear the specific step individuals in California would need to take to be able to play on these legal websites. If the requirements were too extensive, it could prove to be a deterrent to individuals shifting to play on legal websites. The fifth and final factor is related to operator costs. So operators might ultimately choose not to participate in California if the state requires too much revenue, such as from licensing fees or from a share of the gross revenues, because then it would reduce their profitability. Operators would also likely incur marketing costs to drive players to legal websites and encourage them to wager. Additionally, many existing illegal websites offer financial incentives to retain players, such as bonuses to players that can only be collected after playing a predetermined amount of time. This could make it difficult for California legal websites to capture a share of the market in the short run and would impact the amount of revenue that we can bring in. However, the state could also allow for similar incentives. Last but not least, page 7 of your handout provides an overview of how other states have dealt with these issues. So in terms of the types of games, Nevada began offering online poker in April of 2013. Delaware and New Jersey, on the other hand, offers a series of online gaming, including poker, blackjack, roulette, and slots, and that began in November of 2013. In terms of the regulatory authority, both Nevada and New Jersey decided to divide their regulatory, licensing, and enforcement responsibilities between two separate state entities. In contrast, Delaware chose to consolidate all of these responsibilities with a single state entity. In terms of operators, Nevada and New Jersey both restricted the issuance of online operator licenses to casinos or resort hotels that already possessed certain gaming licenses that allowed them to operate in the state. New Jersey actually went a step further and also required that nearly all associated personnel and equipment be housed within their Atlantic City casinos. In terms of the number of websites, Nevada currently has 2, while New Jersey has at least a dozen distinct ones, while the state of Delaware operates online gaming websites through its 3 racetrack casinos. And finally, related to the state tax revenues, all 3 states have chosen to require that operators pay a certain percentage of their gross revenues to the state. However, for your purposes, what we would like to point out is that each state reported that less revenue was generated than initially projected. So, for example, New Jersey initially anticipated revenues of $160 to $180 million. This was subsequently revised down to about $35 to $50 million. In calendar year 2014, that state collected about $19 million in state tax revenues. And so with that, we conclude our comments, and we hope that that is helpful. Thank you so much.
Thank you. Mr. Sharp, please proceed.
Chairman Gray, members of the committee, my name is Steve Hart, and I've been asked today to talk a little bit about about Internet gaming, how it's evolved from a legal perspective. And I think maybe the simple way of saying that is, it seems like just yesterday, Internet gaming was illegal, and now, as we've heard, it's in New Jersey, it's in Delaware. What's going on here? What exactly is the legal history of evolution that's put us in this position? And I'd like to start with the major federal acts that have been involved pre-2000. The first is 1961. The Federal Wire Act. The Wire Act prohibits the transmission of bets and wagers or information assisting in the placing of bets and wagers on sporting events and contests. The president was President Kennedy. It was Robert Kennedy, the Attorney General, who advocated strongly for this measure, together with other bills which were designed to target organized crime. The language of the bill that talks in terms of sporting events and contests was really a reflection of the way gambling, or what gambling was available back then at that time. This was really an anti-bookie statute. That's really what this was at that time. Over the course of time, the Wire Act developed, and it was applied to gambling that occurred either on the telephone or in the Internet gaming or in the Internet environment. Until about 2011, the Act had been broadly interpreted by the U.S. Department of Justice to apply to and prohibit all forms of Internet gaming. It's very important. The Department of Justice looked at this language and concluded this really stopped all Internet gaming in the U.S. 1961, the Travel Act, that's the next big one. That act was passed at the same time as the Wire Act and part of the same group of bills against organized crime. It made it a federal crime to travel or use any facility in interstate or foreign commerce to carry on unlawful activity. An unlawful activity is defined as a business enterprise involving gambling in violation of the laws of the state in which they are committed or of the United States. So the important thing there is that it's looking back. The statute itself, the Travel Act, doesn't make anything illegal. It relies instead on the state law or another federal law. not a lot of federal laws about gaming other than the ones we're discussing. So largely the Travel Act relied on state laws, and that's where the violations would be. The third and the big of the triumvirate, I guess, of the statutes, federal statutes, was from 1970, the Illegal Gambling Business Act. The Illegal Gambling Business Act was part of the Organized Crime Control Act. It was passed during the Nixon administration. It's a very expansive law, very powerful law, but it requires a separate violation of underlying state law relating to gambling, just like the Travel Act did. So both of these, while the Department of Justice interpreted the Wire Act to be a prohibition on Internet gaming, the Travel Act and the Illegal Gambling Business Act both looked for underlying state law violations. In the early 2000s, some chinks began to appear in this armor against Internet gaming. Technology was certainly a factor. Another factor, of course, was the simple reality that states hadn't passed laws prohibiting Internet gaming. So there wasn't something there definitive, and people who had a taste for risk entered into this market. The Department of Justice pressed on. They had some very successful prosecutions in the early 2000s. And they also, in the 2002-2003 era, sent letters out declaring that Internet gaming was illegal. One of the more famous is the one that went to the National Association of Broadcasters, saying, look, you may be aiding and abetting illegal activities because you're allowing advertisements for online casinos and offshore sports books. Another chink in the armor, big chink, was the MasterCard International case. MasterCard International 2002. This was a class action brought by gamblers, not sports bettors, more casino gamblers who were involved in Internet gaming. They sued MasterCard, they sued Visa, they sued a number of the banks, and claimed that this was a RICO violation and a violation of the gambling laws. The Fifth Circuit, and this was the highest court up to this point that had taken a look at the Wire Act, said, we don't understand why that Wire Act's being applied across the board. It looks to us like the Wire Act really only is designed to deal with sports betting. So now you've got the big Fifth Circuit, First Circuit in the states to rule on this, asking questions about the interpretation that the Department of Justice had made with the Wire Act. In the mid-2000s, then, people were wondering if the Internet gaming was going to become legal, if there were things that needed to be done to make sure it was illegal. There was really two train of thoughts on that second point. The first one was, let's just make it clear, this 1961 Act is old, let's make it clear with a new act that Internet gambling is illegal. Washington State did that in 2006. The other thought process at that time was, let's get to the money. This is really all about the money. And that's what the Unlawful Internet Gambling Enforcement Act, UIGA, is all about. It's all about the money. In UIGA, it was included in the Safe Port Act. It was terrorism legislation. It went in at the 11th hour in the cover of dark. No hearings, no legislative history. UIGA took this different tact. Rather than outlawing all of Internet gaming, it sought to stop the flow of money necessary for the industry. So it focused on the financial institutions, establishing penalties for banks and financial firms that processed illegal Internet gambling payments. At the same time as it was doing that and trying to fill a hole that they perceived was there that was allowing the flow of financial funds, it also expressly created safe harbors for interstate, intra-state gambling, intra- and inter-tribal gaming, and for bets and wagers under the Interstate Horse Racing Act. It also has some exclusions in it in its definition of bets and wagers for things like fantasy sports. That's why you see fantasy sports and some skill games emerging now. It's because of some of the exclusionary language in the bets and wagers section of the bill. So that was 2006. The next big thing that happened was December 2011. DOJ issued their opinion, or their memo was provided. And this, after years of the DOJ Criminal Division taking the position that the Wire Act applied to all forms of Internet gaming, casino, blackjack, lotteries, whatever you can think of, the DOJ then said, hold it, we're going to change positions, we're going to follow the MasterCard case, and we're only going to apply the Wire Act to sports betting. I think the specific language is the interstate transmissions of wire communications that do not relate to a sporting event or contest fall outside the reach of the Wire Act. Okay, so now you can see, I think it's been set. With the Wire Act, scope is very limited, and the UIGA's safe harbor provisions are certainly available to states for intrastate gambling. Many believe now that Internet gambling policy is essentially in the hands of state legislatures. It's no longer really the business of the federal government. This, between the congressional will to see states have the right to be involved and the Department of Justice backing off of its aggressive position that it covered all Internet gambling, the net result of that is just a mountain of legislation that's gone forward that was mentioned a moment ago. I'll try to be brief on this because I think I've been close to 10 minutes now. The first is Nevada, 2011 authorization, launched in 2013. Delaware, 2012 operation, I think it launched that year. New Jersey, 2013 authorization, and it launched that year. All three of those are doing some form of casino gaming, Nevada only with poker. The other big movement that's gone on at the same time is the lotteries. This is not to be overlooked. During the same time frame, 2012 through 2014, you see the state lotteries begin to sell tickets online. Illinois, Georgia, Michigan. Michigan's not just selling Powerball tickets online or Mega Millions tickets online. Michigan is selling scratcher tickets. And if you put a scratcher ticket into a computer and you sell it offline, you can make it look just like a just like a casino game. Just the same way you can see in the mini marts when they have a blackjack format to it. You can do the same thing, and that's what Michigan has begun doing. 2015 and beyond, what are we going to be seeing? Well, I think everyone's heard about the Restore the Wire Act and RAWA, and that's one reaction to all of this, and that reaction is, let's back up and let's go back to 1961. Let's make everything in the Internet gaming world illegal. There's a lot of people that feel that won't stop the offshore companies. The offshore companies are here now. Technology is here now. The only way to stop the offshore companies is to provide a good regulated model and to provide resources for enforcement of that model. And that would lead to further statewide authorizations. And frankly, that seems to be what's happening. Right now, Pennsylvania is considering a large Internet gaming proposal. And Kentucky, I understand, is about to join the list of states that have allowed their lotteries to sell Internet tickets. So in short, after the UIGA and the DOJ opinion of 2011, the regulation and enforcement of Internet gaming in the U.S. has now appears to be firmly the business of state legislatures. And these legislatures, as they've been going through this, New Jersey, Delaware, Nevada, there hasn't been any regulatory problems or issues arising. It's been a regulatory success, and I think that's something that isn't really challenged. It's been that successful. So that's the option, and that's the option that I guess you're all here to discuss now. If any questions, I'm available. Thank you.
Great. Thank you for your testimony.